All right, now let's get to actually forming a nonprofit. Now, in most cases, attorneys will advise a client to incorporate, although it's not necessary, and other forms may be able to be eligible for tax exemption under Section 501c3, including LLCs, trusts, and unincorporated associations, assuming they meet certain requirements. But generally, incorporating can provide additional protections to the incorporators that other forms may or may not necessarily provide depending on state law. One point of caution here is that if founders of a nonprofit get together and they start engaging in activities, they may intentionally or unintentionally form an unincorporated nonprofit association. And the issue there is that the unincorporated association may itself be subject to registration and filing requirements. It may need to file returns, federal and state level, and if it's not doing those things, it could potentially be subject to penalties and taxes. And it may also not have the protections in place that actually forming a corporation may. So this can be a good point of caution for attorneys to make to their clients and make sure that they're aware of. Now, a corporation is generally formed by filing articles of incorporation with the Secretary of State or the other appropriate body in the respective state, such as Department of State. Under the Model Nonprofit Act, it sets forth certain provisions that must be included in the Articles of Incorporation, and then certain provisions that can be included in the Articles of Incorporation. And then there's also a few other things that we recommend be included or actually have to be included if the organization would like to file for tax exemption under Section 501c3 as a matter of federal law. So under the Model Act, Articles of Incorporation have to include the organization's name. Now that may seem straightforward enough, but there's actually some limitations on names that nonprofits can use. In most cases, the name can't imply a purpose that's inconsistent with permissible nonprofit purposes. It generally also has to be distinguishable from other entities that are already on file with the Secretary of State. So you generally won't be able to incorporate the same name that's already used for a corporation on file. And then some states also have specific rules regarding specific words that can't be used in a nonprofit's name in order to avoid confusion. Those are words such as doctor, lawyer, state police, bank, mortgage, and other things of that nature. And then some states may also actually require some entities that are non-charitable to include certain words in their name, such as Inc. or corporation or corp, to indicate that the entity is not a charitable entity. Now, the Model Act also requires you to include an address for the entity in the Articles of Incorporation. And the address in some cases may need to be a physical address rather than a P.O. box, depending on state law. You also have to name an agent for service of process. And that's generally someone who can receive legal service on behalf of the organization. It often is an initial founder or a director, or an officer of the organization at the beginning. Most states require the agent for service of process to be an adult over 18 years of age who has a physical address in the state. You generally want it to be someone who's going to be able to be responsible for receiving the notice and communicating it quickly and on a timely basis to the organization. And some states also permit an organization to hire a corporation that serves as a corporate agent for service of process for a small fee. Some states, such as New York, also require organizations to name the Secretary of State as an agent for service of process, which means that nonprofits can be served by service upon the Secretary of State that will then transmit that service to the organization. And then finally, the Model Nonprofit Act requires the Articles of Incorporation to state the names of the incorporators, who will typically also have to sign the articles. Now, articles can also include some other clauses in addition to the ones that are required to be included. And those can include the names of the initial directors, whether the organization will have voting members, a specific purpose statement, which I'll mention a little bit in just a minute, and then generally also additional provisions that are consistent with the law. Now, I mentioned that Section 501c3 also requires some additional provisions to be included as a matter of federal law in the Articles of Incorporation. And it's important to be aware of these provisions because this is one of the main reasons that an application for exemption under Section 501c3 gets hung up. And if these clauses aren't in the Articles of Incorporation, the IRS will require the organization to go back and amend its Articles of Incorporation before it will process its application for exemption. Now, those include a statement of the organization's purposes that states that those purposes are consistent with one or more exempt purposes under Section 501c3. Now, I just mentioned that one optional clause you can include in Articles of Incorporation is a specific purpose statement. Now, although Section 501c3 requires an organization to state a general purpose statement in its articles of incorporation, such as this corporation is organized for charitable purposes consistent with Section 501c3, some organizations will also choose to include a specific purpose statement. So, for example, this organization is organized to operate an after-school program in the Los Angeles County. Now, the benefit of a specific purpose statement is that it might keep the organization or be more likely to keep the organization on track with that specific purpose and prevent its mission from drifting over time. But one point of caution with a specific purpose statement is that if it's included in the articles, the organization is required to act within that specific stated purpose. So in the example that I just gave, that means if that organization's activities shifted over time and it started offering after-school programs outside of LA County or it started offering adult programs, it would have to actually amend its articles of incorporation to broaden its purpose before engaging in those activities. And if you're going to amend the articles, it typically requires filing with the Secretary of State. So for that reason, some organizations will choose to include a specific purpose statement in their bylaws rather than in their articles. Typically, if the bylaws are amended, they don't need to be filed with an outside agency, which gives the organization a little bit more latitude in case its mission changes a little bit over time. Now, a second provision that has to be included in the articles in order for the organization to be eligible for exemption under Section 501c3 is what's referred to as a dedication and dissolution clause. This clause states that the organization's assets are dedicated for use in furtherance of its exempt purposes under Section 501c3, and that on the organization's dissolution, those assets will continue to be used for those purposes, usually by being transferred to another exempt organization under Section 501c3 with consistent purposes. And I mentioned that if an organization fails to include these two specific clauses in its articles of incorporation, when it applies for tax exemption, the IRS will usually require it to amend its articles before it continues to process its application.